landscape is ever changing and continuously changing, sometime every day also. So it is most important for the professional, those who are working in this area, that they should keep themselves updated and they should know what is latest developments and the regulatory area are taking place. In this webinar, which is the first webinar of the month, which we are dedicating towards the recap of recent regulatory and legal updates. So what we are doing, we present the updated and its context, compare it with the old laws, analyze the implication of new law. So these three things we are discussing, and we want to communicate that this is the law, so everybody should be very clear that what is new law. Then we are saying comparison with the old law. And then we want to discuss that what are the implications of this new law and how this will affect the corporate world. So we discuss these things in our first webinar of the month. Now, the question is that how this is useful for everybody. One is this is an interactive learning and comprehensive update. We covered entire thing of this particular month from last webinar to this webinar of the first Friday of the month. Then we give expert insight of better understanding, because these are the people who are providing support to their client. So they have to read and they have to understand and they have to see the implication. And then because they are working with so many clients, so every client has different perspective to understand and to read this. Then we discuss issue resolution through question answers, and then valuable resources, which is CP Connect newsletter, which we are sending to all. As you are aware that we provide whatever changes through CP Connect. Our panel of expert today, they are the person who have the expertise in this regulatory landscape. They will discuss and share their insight in the latest updation, latest interpretation from their side. And they will also discuss the impact of these changes on business and the economy. So I extend a very warm welcome to our galaxy of speaker today. I welcome Mr. G.P. Madan for this program. I welcome Amit Gupta, who is a practicing company secretary, insolvency professional. I welcome Ankit Singhi, head corporate affairs and compliance, corporate professional. I welcome Ms. Mohini Vashne, partner head ESOP and insider law service. And then I welcome Nikita Vijay, senior associate, securities law and corporate litigation, corporate professional. So friends, these are the people who are working in different area. Ankit and Amit is doing work on company law and security law. Madan is doing work on insolvency. Mohini is in ESOP and insider trading. Nikita is working on the securities law. So these people are discussing, interpreting, and talking to their client. So after reading what is their interpretation and how they want to communicate to us and communicate to all the participants, that is important. And I'm confident that this webinar will provide valuable platform for learning and discussion. And I hope that it will help us to gain better understanding of recent regulatory changes. And I want to inform all of you that whatever changes in the month is coming, we are giving in the form of the CP Connect. And the CP Connect, which covers all the regulatory updates of the month, important case laws, articles, compliance calendar for the month of August, and CP Think Tank, in which you will get the update regarding our new publication and all webinars. So this is the two things which we are doing, the updation as well as the newswire in the form of CP Connect, which will be useful for all. We are sending to the participant of the webinars as well as we are sending to all other people. So today there are so many changes has come relating to company law, relating to SEBI, LODR, insider trading, and then various things of information, this listed entities and debenture trustee, and some debt instruments, listed debt instrument, and then the most important change which has come, the dispute mechanism, resolution dispute mechanism, which SEBI has come out the dispute resolution mechanism through online process, and then some changes for the foreign portfolio investors. So all these issues we will discuss today, and I hope that everybody will understand. And now I will request Ankit. So the program structure will be like this. First, Ankit and Amit Gupta will talk about the changes in company law, SEBI circulars, and amendment of non-convertible instrument. Then Mohini will discuss about SEBI circular and trading window closure. Then Nikita will discuss about the dispute resolution mechanism and foreign portfolio. And then Madan will discuss about the insolvency case law, which has come, which are very important. So over to you, Ankit and Amit. You give your presentation relating to company law and security law. What are the changes has come? Over to you, Ankit. Your presentation is visible. Yes, Ankit, you have to unmute. Your voice is no. No, it is not. Voice is not coming. Ankit, you remove this and then it may come. No, it is not coming.
Hello.
Yeah, it's okay now.
It's okay. Okay. So Shivam, can you move the slide? So we'll start with the company law update. I think apart from the mess that is there on the V3 portal, there is only one slight amendment that was introduced just day before yesterday, I believe, with respect to notification under the incorporation rules, whereby the form RD1, which is being used to file applications with the regional director, has been amended, and a new version of RD1 has been substituted in the notification rules. While there are optically changes under the form, there is a specific column pointer now added for filing an application for approval of scheme of merger under section 233 with respect to small companies and subsidiaries in CA 11. That has to be, while that all was originally also be filed in RD1, but now there is a specific provision in the form itself. And when you click the option, then this form also asks for certain additional details in respect of the application, the debenture holders, creditors, their value. And then there are other details which have been asked in respect to application for approval for conversion of a public company into private company, or for a financial year. So there were certain other optical changes that have been made in the form. So this is the only change that is there under the Companies Act. Now moving along with the respect to the provision on directors nominated by debenture trustee. So I think SEBI has been dealing with this issue for quite some time now. Earlier, they issued an amendment mandating companies which have issued debentures to amend their articles, mandating for appointment of debenture trustee appointed director in case of default of repayment of debentures, or any payment or event of default as identified in the agreement entered into with the debenture trustee. So there was this obligation which was casted on the entities which have issued the NCDs as part of the process to ensure that in case of default, there is no issue or challenges faced in the appointment of debenture trustee nominated director. But then the debenture trustees, I think, made further representation to the SEBI, where they specifically mentioned the problem that they were facing with respect to, first of all, entities which are not companies, because that earlier amendment talked about amendment of article of association of companies, but debenture trustees raised this point that there are a lot of entities which issue debentures which are not in form of companies, and then they are subject to their specific special law like PSUs, which are bound by their own set of regulations, where directors can only be appointed by the President of India, and there are no at times there are no specific charter documents. So they were finding it difficult to ensure that the debenture trustee is able to nominate their director as and when they are required to do so. So for that purpose, SEBI has issued this circular in the last month, where they've asked all such entities which are not basically companies and to give an undertaking to the debenture trustee that in case at any point of time the debenture trustee is required to appoint a director nominated by a nominated director on the board, then the companies can appoint any non-executive, independent, or any other director out on the current board as the nominee director of the debenture trustee, in case they find certain issues in appointing a director specifically nominated by debenture trustee on the board in consultation with the debenture trustee. So this is an undertaking which all these companies have to give. So this in way is trying to find a middle path where companies are finding it difficult on account of being governed by their special laws or special set of regulations, where they are not able to easily appoint a director nominated by debenture trustee. For such companies, a middle path has been outlined in this circular. Moving ahead, I think I think March board meeting of SEBI, where they approved the major amendments in the LODR regulation. One of the important amendment that they also approved is with respect to introduction of the concept of BRSR core. So BRSR core is in addition to the BRSR in two ways, that there is a separate report in BRSR core in terms of certain key elements, and then they have also amended the BRSR to introduce the elements of BRSR core in the BRSR report itself, which companies of top 1,000 entities on FY24 and 23 also will be required to adopt the new set of BRSR, which has been issued as part of this circular. A new format of BRSR has been issued, in which elements of the BRSR core has been outlined. And the another requirement of the press release was to also obtain companies ensuring preparing BRSR to obtain reasonable assurance. So for that, they have issued a glide path. So for companies, when they will be preparing the BRSR report for financial year 23-24 starting onwards, then in these manner, top 150, top 250, top 500, top this 1,000, these entities will have to obtain a reasonable assurance from an independent service provider who board believes is having an expertise to give an assurance. And then going forward, can you go to the next slide? No, go back. On the BRSR core, there is also a report which have been issued by BSR core has been issued separate report, and that element has been introduced in the BRSR full report. So BRSR core is basically collates quantitative data out of the BRSR report, and it talks about assurance on data related to environment like scope 1, scope 2 emission, usage, consumption, discharge of water, welfare measures or related to employees, openness in terms of the business, like whether business is concentrated among few purchasers and sellers. Then with respect to employment and employee well-being, post-related complaints. So there is a lot of quantitative data that is provided in BRSR core. Some have been taken from BRSR report, and some new data has been provided in the core report. So on this core itself, the assurance has to be taken, not on the entire BRSR, only on the figures or quantitative data that has been disclosed in BRSR core. the assurance has to obtain on that. And then certain guidelines have been also provided in the core report itself as to how, what factors will be considered while an independent assurance provider will give assurance on BRSR core. Next. Now, there is also a requirement on companies to provide details on BRSR code with respect to their value chain partners. So value chain partners was there in the SEBI board meeting, but to which to what kind of companies, class of companies will be required to obtain this report for value chain partners was not prescribed. So this has now been outlisted, 50 listed entities. From financial year 24-25, they have to now give a report on the BRSR core on the value chain partners, and they also have to obtain assurance on these value chain BRSR code details on comply and explain basis from 25-26. So both to prepare, give disclosures on value chain partners and to obtain assurance on value chain partners starting from 24-25 and then 25-26 for assurance. But both these requirements is on the comply and explain. So it is, if you are not able to comply with this requirement, you have to give necessary explanation in your annual report. Then what, first of all, we also need to understand who is value chain partners. And it says value chain partners shall encompass the top upstream and downstream partners. If you can go back on the slide, Shivam. So value chain partners, so upstream and downstream. So for a company, a value chain partner is in terms of upstream is from the value chain vendors or purchasers from which it sources its raw material and other important products which contribute to the finalization or manufacturing of the product which the listed entity produces. So all those vendors from whom they are procuring their raw material and other stuff will form part of the upstream value chain. And then when they distribute the final product which they are making, then to the vendors through whom, like wholesale distributors, large retail vendors, all these will be forming part of the downstream value chain as part of the value chain for a corporate. So upstream is from where you source your raw material, downstream is where you send the final product. This is how upstream and downstream value chain vendors will be identified by a company. Most of the companies who are into this phase have already list of their upstream and downstream value chain partners. Next. So with respect to these upstream and downstream, comprising in terms of 75% of purchase and sales, total purchase and sales which the company does by value, 75% on the vendors forming part of the purchase and sales in total, the company has to give report on BRSR code. It can be given in an aggregate manner of or the all the upstream and downstream partners by way of, I think, averaging, or it can be segregated by giving a report for the upstream value chain partners and downstream value chain partners separately. And in case the companies don't want to give, they can always explain the rationale as to why they have not disclosed the parameters in as part of their BRSR core for their value chain partners in their annual report, because this has to be complied on a comply or an explain basis effective from financial year 24-25. Next, yeah, sir.
Okay, just tell me,
Hmm.
Suppose there is a one company X. Go to value chain back, just go back.
On the diagram, yeah.
Yeah. So this is a listed company, manufacturing, and they're supplying an upstream value chain partner and supplying to the downstream. Now you are saying 75%. So 75% mean there are suppose the upstream value chain partner is 50, okay, and they are providing something which is cumulatively coming 75. So all 75 will be coming in this category.
So basis 75% value, they will identify the value chain vendors who are forming part of the contribution towards 75%, and out of those value chain partners, they will run this exercise of determining the quantitative data on BRSR core parameters, and then they will disclose accordingly.
And second issue is it not a big issue now? Suppose I have a manufacturing company and I have to take care of my upstream and downstream value chain partners, and this is my responsibility. So these are the MSME, small companies. So you are putting this responsibility on company, that is okay. But now I have a responsibility to these upstream and downstream also. So it is not a big work, and they require so many consultants, so many people, those who can advise them.
I think definitely, I think the reason why they have put on the obligation on the listed entity is I think that they will now be taken as part of their sustainability effort to ensure on both the sides, upstream and downstream, that they can help their value chain partners in attaining sustainability in their businesses, and try to implement ESG related norms. If you see, sir, globally, European Union and all others have mandated their companies to apply sustainability guidelines. And these guidelines, they have also been mandated. These companies are also mandated to ensure that their value chain partners are also complying with these guidelines. So we recently also come across with such cases where one European client terminated a contract with an Indian manufacturer and moved on to the other manufacturer just because he was not complying some norms related to pollution, and the other manufacturer was complying. So in order to, because they are now also responsible to their own stakeholders globally to report on their ESG practices. So all these now will become very important as to how serious you are in terms of your own business, and how your value chain partners, both upstream and downstream, are taking part in your effort to ensure that sustainability is achieved through various processes that you implement, either by way of contribution to environment, or by way of contribution to both social well-being of human beings, or other as part of the governance practices you adopt.
Absolutely right, Ankit, absolutely right. But I think I'm seeing a big business, big consulting opportunity for people, and simultaneously companies have to be on their toes now. So this is one move.
I think that is why they have implemented. They have given some time to listed entities to ensure, talk to their vendors to find out to what extent they are in compliance. Sir, even if you see, sir, current BRSR or even BRR, it also already had certain questions. For example, whether you are sourcing sustainability from your vendors, whether your vendors were in terms of like labor employment, child labor and other things, to what extent they are complying. So companies were already to some extent disclosing some parameters on these issues. Now these issues have taken a much bigger shape, and when you will be talking about, or one day when assurance will become mandatory for value chain partners, I think the real game will be in play from that time. Because once you start taking assurance, then you cannot just put any numbers across as part of your reporting. You have to make sure that everything which you are reporting is in line with what is actually being followed by these companies. So there is no doubt ESG is the one of the biggest things today and for times to come, where we as a professionals across can look and try to develop ourselves, because this is not something which is totally related to law, but has some element of law. And also you also need to have understanding of how industry works, how various processes works, in order to make a deep dive. So going ahead, Shivam, if you can just take to the next slide. I think this is done. The assurance provider, have already talked about that it has to be an independent assurance provider where board is of the opinion that they have the necessary expertise. You can take to the next slide. So regulatory updates under Regulation 3030A, since the new amendments which have been notified, there have been a lot of buzz on both the changes under Regulation 30 and much importantly Regulation 30A. So SEBI, in order to provide some relief, has come out with a circular, I think on July 13th, where they have outlined certain key elements concerning disclosures under Regulation 30 and 30A. Though a similar circular was, I think, already there before this amendment. I think it's of September 2019, which talked about similar aspects which is covered by this circular. But since there have been numerous changes recently under Regulation 30. I think it was good on the part of the SEBI to come out with a fresh circular repealing the existing one, outlining the new guidelines. So the circular has 4 annexures. That first annexure is with respect to the details that you are now required to disclose as part of the disclosures or events that needs to be disclosed, both under para A, para B of part A. This was there earlier. In some items, some additional information have been added, and for all those new items of disclosure that have been added, details have been provided what needs to be disclosed. Second, annexure second is very important because now, as per the regulation, apart from the board meeting, there was 2 timelines of 12 hours, 24 hours within events within the organization, events outside the organization. There was a lot of confusion as to how one would determine which is an event within the organization, which is an event outside the organization. So I think we should be commending SEBI for doing a good job in outlining, making this easy for all the stakeholders by outlining specific time period for each and every disclosure that is there in para A and para B as to within whether it needs to be disclosed within 30 minutes or 12 hours or 24 hours. Standard principle is whatever is discussed at the board, 30 minutes, and then thereafter 12 hours or 24 hours basis the guidelines that have been given as part of the annexure second. Annexure 3 is similar to annexure, the similar annexure in the last circular. Nothing much has changed. I think there is a small paragraph that was there that where in principle approvals were given, those need not to be disclosed. This para is not there, but I think the principle will still continue where only in principle approvals have been given at this point of time. No final call has been taken on board on a particular decision. For example, an opportunity has been approved in principally to explore. Nothing has been. There is nothing definite at this point of time. I'll still continue to not disclose the same unless and until you take a final call either by the board or either by the person authorized. Then both the things remain same. Shivam, we can move ahead. Shivam, can you move? So,
अंकित लाइट का तो इम्पैक्ट नहीं कुछ?
Sir, yes, I think there is a shutdown. Let me just try to find a way. Just give me a second.
You can continue with your presentation without.
Just give me a sec. I am putting it, sir, back.
अंकित में प्रॉब्लम आ रही है.
चला है ना फिर?
My screen is visible.
Yeah, yes.
Okay. So we were onto this. So nothing much has changed. In respect of the guidelines, there is an important annexure which helps in one of the fundamental question that everyone was finding difficult to understand with respect to the calculation of materiality limits in case of average of net profit, where it was a word used were absolute. So now SEBI has also clarified that when you say absolute, you have to ignore the plus or minus sign. Just consider the values in their context and do an average and take the percentage out. You need not to consider the plus or minus sign. So in order to average, if there is a minus or positive and negative sign, you need not to add them. You have to just ignore the positive and negative signage and just consider the value as it is. Do an average and take out the percentage in order to determine the value for the purpose of considering the materiality.
Ankit, just explain this number again.
So, sir, like for example, as I mentioned that in case if you see FY21, FY22, 23, FY21 there was loss, FY23 there was loss, FY22 there was profit. So in general context, if we have looked into it, it would be 2020 plus 50. So the sum would be 10, and then we would have an average of 3 divided 10 divided by 3. But now we need not to consider the negatives of 2020. So 20, 50, 20, all three will be considered in just numbers, ignoring their negative and positive sign, and then we do an average. So now 20, 50, 70, 20, 90. So 3 divided by 90, 30. Otherwise 10 divided by 3, 3.3 something would have been the average. And then you take the percentage of 5% for coming out on the value for the purpose of materiality. So you have to just ignore the positive and negative sign attached to the number. Just consider the absolute value of number itself.
But it will not affect the various companies, those who are loss making.
But sir, it will, if their number is huge, then it will also help you in getting a higher materiality limit. So for example, if someone is having 100 crores, 200 crores of losses, and then 50 crores or 20 crores of net profit, so that 100 crore will ultimately contribute towards increasing the materiality limits. Because otherwise तो आप एवरेज कर लेते तो कम आ जाती फिगर्स माइनस से, बट यहाँ तो आप जब उसको करोगे ऐड को, तो इट विल गिव यू अ क्वांटिटेटिवली एंड हायर नंबर इफ द लॉसेस आर बिग.
Okay.
So this is another thing. Now I'll request Mohini to take this forward.
Yeah. Good evening, everyone. Ankit, okay. Thank you. So with respect to the freezing of the PAN number of all the designated persons at a particular security level by the depository and the exchanges. So this circular way back in last year 2022, on 5th of August, SEBI has issued this circular mentioning that the PAN of all the designated persons will get freezed auto by the depositories during the trading window closure time period. And at that time, from 30th September 2022, they have mentioned to start with Nifty 50 companies and the companies who are in the which are in the Sensex. They get this 30th September 2022 auto closing of the PAN at their particular security level. Security level means that particular company in which that designated person is a DP. So, for example, the Reliance company employees or the designated persons, PAN number will get freezed for the security of the Reliance Industries only. So in August, from August, this circular came, and the Nifty 50 and the Sensex companies are now being, they are under into continuous closure for those PAN number since 30th August, 30th September. After that, recently in June, after almost a year, on June 28th, again the NSE has come out with a circular wherein it is mentioned that how the remaining companies will be covered under this PAN freezing. So they have mentioned that the quarter end, the stages will be the quarter end 30th September, then 31st December, and then 31st March. So this circular, after this, after the circular of this exchange on 28th June, now recently in July 19, SEBI has come out with the proper schedule that how the listed companies, the remaining, that means after Nifty 50 and the Sensex, how their PAN will be freezed. Next slide, please, Ankit. So this is the schedule. So the schedule is like that top 1,000 companies in terms of BSE market capitalization as on 30th June. They will be, their PAN numbers get freeze from 1st October 2023. Then the next 1,000 companies in line, then their PAN will be freeze from 2024 January. That means the next trading window closure time period. And the remaining companies listed on BSE, NSE, and MSCI, after all the excluding all the above three, they will be from 1st April 2024. So by the 1st April, when the trading window closure of that particular financial year will start, the DP's PAN with respect to that security level get freezed. And for the companies which get listed post issuance of this circular, that means after this July circular, so whenever the company is getting listed, For them, the first day of the second quarter from the quarter in which the company get listed, their PAN get freezed. So this is the time manner in which the this PAN of the designated persons get freezed. Next slide, please. So how this Ankit, next slide, please. Next. Yeah. The process has been eased out and the process has been described that how this PAN freezing will be done. So we all are aware of that way back in September in 2021, the circular has been issued by the SEBI, wherein they have introduced the system-driven disclosure. So from that circular itself, all the listed companies has to provide the PAN number of their designated persons to a designated depository. So the company has to choose that they can opt from NSDL or CDSL, the depository. And that designated depository, they have to share the PAN number of the designated persons, promoters, promoter group, all these they need to share. Once they share those numbers, from there itself, this PAN freezing will be done. So along with the PAN number and the name, the listed company time to time, whenever the trading window closure time period comes, they have to update in that particular depository the ISN, the start date and the end date, and particularly the ISN of the securities which they want to freeze, because they might be the equity and debt both are listed. So they have to mention that which ISN they want to freeze for them. This need to be done, this updation of the date and the updation of the PAN, either deletion or addition, they need to do before at least 2 days before the starting of the trading window closure. So T is the trading date, trading window closure date, then they have to go by -2 thing. Once this -2, they will update. Next, the one day the depository will take, and then immediately the next day the designated depository will coordinate with the other depository and the exchange for the freezing of this PAN. And ultimately, on the T date, the exchange will freeze their PAN of the DP at the ISL level. So this is the process how this PAN freezing is being done by the exchanges. And any addition, further and any deletion of any DP, even during the trading window closure period, need to be done. That also be given effect within the 2 days of their updation. So this is how the circular will come in.
Mohini, there are two important things in this. First is that with respect to, for example, if you have to exempt any person from trading window restrictions as covered under para 4 of para 3 of schedule B, then also you have to go and uncheck their names from the list of DPs. But one thing needs to be mentioned, taken care of, and you also mentioned that all these changes are will take place on T+2. So considering the same, for example, if a pledge has to be created, then in discussion with the DP, you have to inform them that I am removing your name today, and then after T+2, you can create a pledge. The another important point that they have referred to a past circular which they issued for the SDD for the first time is with respect to adding the names of DP. So if you read that circular, that talks about on a immediate basis.
Correct. On an immediate
basis. How you advises companies to ensure that as and when a new DP is added, how they first of all make sure that the compliance team is informed about the addition of new DP, and within what time then they have to add that name on the SDD, if you can throw some light.
Yeah, so the circular talks about an immediate updation. It's very correct, and immediate deletion as well. So I think the circle will starts from the HR team, because they are the person who knows about it when the person is joining and what is his last working day. So immediately the HR of any company that has to inform the compliance officer that how they need to that this is the person who is joining on this particular day. So on that very day, the compliance officer's duty is to update the PAN number of that person in the depository. And I think if we read through this circular itself, so but before that, we need to comply with that SDD circular, that immediate basis, because this is saying that in case any addition deletion is there, you have to update it by -2. But I think the companies has to follow that system-driven disclosure, and on immediate basis they need to update. And even on the same day of the resigning, they need to remove that person. The reason is because it's the pan freezing only, but that is system driven. If the person trades, then when it crosses the 10 lakh limit value in the trading, then that the exchange has to display. So because of that, the immediate addition and the deletion need to be done. And in one of the webinar, SEBI has also suggested that try to make it that if the person is joining or some resignings are there, try to get it done in the weekends time so that it can be easily updated over the portals.
And is this requirement of freezing also applicable on debt entities?
So yes, because they have mentioned the ISN and it's for they have mentioned in the circular itself that it's for the, but here they have said about the pan freezing at the security level. The security is with respect to the security, they have, it's for all the, but here they have mentioned only about the companies which are in the market capitalization. So I think we are talking about only the equity.
I don't think only equities are.
It's an equity to start with. It's an equity only. Yes.
Moini, just tell what will be the impact of this. Otherwise, previously, when they have not, is it a good for the corporate world or what? Good for compliance officer? What do you feel?
It's good because otherwise, generally the designated persons many a times are not aware of that they are prohibited from trading during a particular time period. So the people will get into any unintentional kind of a trading. So to avoid that, if the designated person's PAN numbers get freezed auto at the exchange level, so it will be good. It reduces not only the compliance officers compliance thing, but also it helps the designated person that they can avoid any unintentional default of this trading window closure time.
So in a way, it is directly going. So the compliance officer should not manage everything, and then they should see the violation, and then they should. I
Yes.
think that's a good move for the corporate one, especially compliance officer.
Compliance officer.
And I think, sir, going forward, this will be mandated for all type of trading window closures. Because this is now financial result, but going forward, I think it would be much easier for compliance officers to ensure compliance if on every occasion of trading window, the DPs of demat account of DPs are freezed. So in that case, they will not be able to undertake trading in the share. So then the entire objective of avoiding insider trading can be achieved.
I think because they have given us the portal they can update their trading window starting date and closure date. So I think for every occasion, if notional, even if within the organization for few designated person they are closing, I think the process will come that they can also close for the other things as well.
That's good.
Thank you, Mani.
Yeah, thank you.
Okay. So now this SEBI has come out with this dispute resolution mechanism online. So Nikita, I will request you.
Thank you, sir.
Two changes. One is portfolio management and this one. So please suggest first, what is this mechanism? Mediation, everybody understand, but why SEBI has brought out this and who all are covered and what will be the changes?
Yes, sir. So SEBI has come out with a notification on 3rd of July, which amended these regulation concerning merchant bankers, AIF, vault managers, RTAs, etc., all the market participants related to the securities market, which basically specifies that all the dispute resolution mechanism will include mediation, conciliation, arbitration if there is any dispute which arises between the investors and these investors or clients and the market participants. So SEBI then, to clarify and with a detailed procedure, came out with another circular on July 31st, 2023. Next, please. So this online resolution of dispute, this ODR mechanism basically has to be implemented by the market infrastructure institution, that is majorly the stock exchanges and the depository participants, the designated depository participants. They have to come out with an online portal, a proper ODR portal, somehow similar to the scores portal that is there in the SEBI website. So all the disputes between the investor, clients, and listed companies or any of the intermediaries, regulated entities in the security market arises from the activities either of the listed companies or the intermediaries will be resolved in accordance with this circular. It also provided that the investor, so there are certain parameters based upon which this ODR procedure, the ODR procedure will be initiated. So firstly, before referencing their dispute to the ODR portal, they first have to make a complaint to the market participant. If the market participant had not given them a satisfactory reply, or they are not satisfied with the resolution of their dispute, then they have to move to the scores portal. If still they are not satisfied with the result of the resolution by the under the scores portal, then they will choose to go through this online dispute resolution portal. In this online dispute resolution portal, there are two stages. One is conciliation and mediation / conciliation, and the other is arbitration. So firstly, this ODR portal will provide an opportunity for the market participant to concile with the investor and the client. So there will be an independent conciliator which will be appointed from the panel of this ODR mechanism, which will be instituted by the MIIs. Then this conciliation will take place if the investor is not satisfied with the there is total 21 calendar days that the disputing party should settle their disputes. An extension of 10 calendar days is provided. If the parties are not able to resolve their dispute within this ambit, then then the investor client can further their dispute to the arbitration. If they're satisfied with, if the investor and the client is satisfied with the resolution, then a settlement agreement will be executed. Then in case of the arbitration, again there will be an independent panel from which arbitrators can be appointed, and investor client can refer their dispute to the arbitration. If by going into the arbitration, the market participant has to deposit a fees of 75% of the claim. The claim will be decided by the conciliator at the first stage. That admissible claim value, 75% of that has to be deposited by the market participant or the listed entity. If they fail to do so, if the market participant fail to deposit 75% of that claim value, then the consequences will be taken by the board. It is also provided in the circular that market intermediary can also be considered not fit and proper under the SEBI intermediaries regulation, and the consequences of if not being a fit and proper intermediary can result in suspension of their activities and also cancellation of their license to act as a market intermediary. Similarly, for the listed companies also, if they also fail to deposit 75% of the amount in the admissible claim value, SEBI can accordingly, stock exchanges can take action against them also. Next, sir. So this I have already covered, that if they are not satisfied. Next, sir. Okay, one more thing which is not covered in the presentation, I would like to clarify that what kind of disputes that can be taken under this ODR platform. So it can be only with respect to the which matters are not appealable under 15T of SEBI Act, which are not appealable before SAT, and which are not appealable under 23L of SCRA. Only these kind of disputes can be taken in the ODR portal. Next, sir. So with respect to the amendment in FPIs, so now SEBI has come out with a circular on 23rd come out with a circular recently, where they have clarified that all the existing FPIs that had not already provided their legal entity identifier number, they have to provide the same to their designated depository participant. So basically, what is an LEI? LEI is basically a unique global 20-character code, which is used to identify the legal distinct entities to engage in the financial transaction. So these LAIs earlier in the customer acquisition form, when the FPIs wants to get registered with the DDPs with SEBI through DDPs, they just this LI providing this LI number was a voluntary vote. It was not mandatory, but through this circular, they have provided that from now on, all fresh registrations subsequent to issuance of this circular shall be carried out upon receipt of the FPI's respective LEI details. And accordingly, DTPs has to carry out all the necessary changes in the customer acquisition form also. And the existing FPIs which have not provided their LEIs in their customer acquisition form, they have been given 180 days from the date of issuance of this circular, which comes out to be 23rd January 2024. In addition to this, I would also like to discuss two important case laws that have been decided by Securities Appellate Tribunal recently. So if everybody must have heard that SAT has come out with an order with respect to Reliance Industry Holding Private Limited versus SEBI on 28 July 2023. So I'll just explain the facts in brief. So by this appeal, the promoters of Reliance have challenged the order dated 7th April 2021, which was passed by the AO, and it has imposed a hefty penalty of 25 crores under Section 50H of SEBI for violation of Regulation 11, Sub-Regulation 1 of SAS regulation. So Regulation 11, Sub-Regulation 1 of old SAS regulation 1997, basically provided for giving of an open offer when you have breached the threshold. The threshold was that if you, on the date of the commencement of the SAS regulation, the threshold was if you are above 10% and below 51%, and then you acquire more than 5%, 5% of the voting rights in the listed company, then you have to come out with an open offer. But so the facts surrounding these and the issue of consideration in this case was, in 1992, REL approved the issuers of some redeemable convertible, some non-convertible debentures along with some warrants. In 12th Jan 1994, RIL allotted 6 crores NCDs to 34 entities of 300 crores along with 3 crores detachable warrant, and these holders were entitled to receive 2 shares on conversion of these warrants. These warrants had a timeline of 6 years to get converted, and on 7 Jan 2000, so at the time of issuance of the warrants, SAS regulation 1997 was not in place. So in 2007, when these warrants were converted and they were allotted the voting rights, they did not come out with any public offer. That was the allegation made by SEBI against the appellants. They said that when you have when these shares were converted into shares, you were obligated to make an open offer and to make a public announcement, which you have not done. So they have imposed a penalty of 25 crores. But the issue of consideration here was that whether the Regulation 11(1) will trigger upon issuance of the warrants, or whether on conversion of warrants. So in this, and whether the SAS regulation can be applied retrospectively. So in this, SAT has provided their opinion that on the date of the issuance of the warrant, SAS regulation was not there, and the definition of acquisition provided in the SAS regulation, it says it does not include any term which says conversion. If that was the intent of the regulator, then such clarification must have been provided in the regulation itself. But it just says acquiring of voting rights or agree to acquire voting rights. So as per SAT, when this issue came before 1997, they have agreed to acquire, and at the time of issuance of warrants, since there was SAS regulation was not there, so it cannot be made effective retrospectively. So SAT, in conclusion, set aside the order, and they have directed them to refund the penalty amount of 25 crores to the appellants.
Do you think this case, this decision is on technical ground or on the logistic view?
Sir, it is basically on technical only, because it is right, because when the definition accusation includes agree to acquire, so in every transaction, if somebody has come into an agreement, so the first triggering point comes when they agree to acquire.
Okay. Okay. So now what changes you will see in this online dispute resolution?
Sir, it will help since I think since COVID, there has been a lot of change, and this kind of mechanism is basically online dispute resolution mechanism. So they want to and if we see the particulars of the circular, everything is in time bound manner. If anything is not done within the time bound manner, then it will help in resolving the disputes. Sometimes investors have nowhere to go. They keep on submitting complaints, they keep on sending letters to the market participant, but no satisfactory resolution comes for these small investors and clients who are dealing with these market participants. So I think it is a very robust move by SEBI, which can help in the security of the interest of investor, keeping in mind of the interest of investors. But I still feel in the implementation phase, since now in the month of August, they have made it applicable only on the trading members and subsequent market and the depository participants, because
Okay.
I think they are the largest in numbers with respect to the market one. Other market participants will come in phase 2. So I think when we will see the implementation of this ODR portal, there might some challenges that would be faced by the MIIs, and there might be some challenges when investor client is not satisfied with any of the result. Then how it will be resolved by the MIIs?
Nikita, does it also intend to include scores related complaints going forward?
Sir, a scores related complaint, it does not as such include scores related complaint. It is basically saying that it is a preliminary condition that first you have to make a complaint to the market participant. If you are not satisfied, then you have to go to scores portal.
No,
Then also, if you are not satisfied, then you can access to this ODR the mechanism.
So as an investor, I can access to that.
Yes. But you
Okay.
have to first exhaust all your options. Then this option will be available to you.
And one of the subject matters you mentioned in the slide is LODR, SEBI LODR regulations.
Yes.
So in case of any, for example, at times exchanges levy penalty on us or fines for non-compliances. So we can also take those disputes to this panel.
I don't think so, sir, because if you see the applicability of these regulation, it says basically investor client and listed entities or market intermediaries for the latter's activities. So the intent is basically with respect to disputes between investor and the listed company, client and the intermediary.
No, so okay.
Yes.
And so I think it's on. They are going on that faceless kind of
Correct.
assessment that is there in the income tax. How you faceless handling of matters. Adjudication.
Yeah, this ODR mechanism is, I think, used by many banks, and which I have read somewhere that this ODR mechanism was earlier adopted by certain banks, and also they want to provide this mechanism for this to in the for securities market as well.
Okay.
Thank you.
Thank you, sir.
So Nikita, what is the this FPI changes? Will it change anything?
Sir, it is basically for to better regulation of the FPIs. So if there's any transaction going on, if there's any transaction in the securities market, it is just a move to better regulate the FPIs.
Okay. So now these are the updates for today. Ankit, can you just tell me when you were talking about this LODR, what are the issues industries are facing? What the point, like in ordinary course of business, there's a one word. There are one problem which was there, which SEBI has clarified about this 3 years profitable record. So what are the new things which you can suggest?
But I think the all these things were there earlier too. The problem is arising out of the fact of because of the new materiality criteria. If you see, many of our clients are having materiality which were they were earlier having, for example, 10% of the turnover, 10% of the net profit, which were in ranges of 50 crores, 100 crores, 70 crores. Now, because of these new materiality criteria, in some cases it has come down to 10 crores, 12 crores. In one of the cases, it is 6 crores. So the problem is arising out of the fact of the new materiality criteria, because all these things, majority of stuff of in para B was there earlier too. But because of the discretion at the end of the board to determine the materiality, and both in terms of quantitative and qualitative criteria, most of the cases companies were able to excuse themselves from making disclosures under para B. But because of this new criteria where the threshold has been taken to a very low level, the challenges have now started rising, and companies are now trying to read in lines with respect to disclosures required under para B. Most importantly, with respect to disclosure that is required on the lines of like bagging and awarding of order, not in normal course of business. So first of all, it is both awarding you if you give the order or if you get the order. Both the things are covered, and then it talks about not in ordinary course. So ordinary course, while if you see as a business, most of the things that you do during the course or during the normal operations, and all the orders that you get and all the orders that you give are generally forms part of your ordinary course. But in certain circumstances, there may be cases that, for example, an order which was a vendor which was giving order generally, for example, 100 units, have suddenly started giving you order of 1,000 units. Then it can be said that this was not an ordinary course. You get orders from one of the known vendors internationally, which you were not earlier supplying to, then it can be said to be a big order. In terms of modification, like cancellation of order, that can also be one thing, where an order of a big amount was cancelled, which is not generally the case. So there may be a lot of permutation and combinations involved in to determine what would be in normal course or not. But generally, as per set principles, normal courses is what is there in customary business practices. Traditionally, that is happening in the industry. In terms of your trends, that is generally what is how businesses are operated. So one has to be mindful of all these factors to determine how they will ascertain whether it is an ordinary course or not. And it's better for companies where then there is a lot of subjectivity involved to get some criteria approved from the management or from the board to take a call as and when the exchanges will reach out to them for non-disclosures. Because if we have certain set criteria in the materiality that, okay, this will be material, I understand, but whether that's in ordinary course or not, that is something which I can take a call. If you can get these criteria approved from your board, then under these circumstances, we'll take this as an ordinary. Under these, we'll not take that an ordinary. And you follow those criteria while making your disclosure. In case as at any point of time, exchanges reach out to you for any order which you have not disclosed, you have something at your end, some processes at your end, which you are following to conclude whether something needs to be disclosed and not. And if I have implemented those systems and processes, then I don't think even regulator will be able to bring its own wisdom in the areas of expertise of my operation or my business as to what would be normal and what would not be normal. So we need to have specific set of instructions, processes on various such disclosures like disputes, ongoing disputes, current new disputes, how you determine. Then there is also a requirement of disclosing the continuing events on or before 14th of August within 30 days of the coming of effect into the of the new amendments. So para B has to be analyzed in terms of what is ongoing, what needs to be disclosed to the exchanges if they are meeting the materiality criteria. So there are a lot of things which are challenging also, and which is making the life of compliance officers very difficult these days. But I think if you are able to set some standard, I think things will normalize in times to come. And going ahead, we will be able to see. We will definitely be able to see large number of disclosures being made by entities, uh, and a lot of, I think, awareness will also be there in terms of what needs to be disclosed and what needs not to be.
Okay. Okay. So the most important point, if you are seeing, what is your view, Ankit, relating to these changes which are taking place? Because in company law, they are changing, in civil law, they are changing. Every day something is happening. So do you think that some other issues which they have come out in LODR, something is not clear? SEBI is giving the clarification regularly, but something you think is require more clarification, more clarity?
I think the timeline was an issue which was there. Some clarity was required, and as I mentioned, SEBI did a good job by outlining the timeline in terms of within the company, outside the company. The one major issue where companies are finding it very challenging is with respect to, I think, para 21, that deals with regulatory orders on fine, penalties, cautionary statement, suspension, where there are a lot of issues in companies in complying with, because companies having operations spread across globally, getting such kind of notices sitting across one corner of the earth are regulator issues, or implies puts a penalty on their company, escalating it to the compliance officer. All these things takes a lot of time. And then when we need to see the materiality, because recently if you see KFC, one operator of KFC filed an order with respect to imposition of fine of 10,000 rupees. 10,000 rupees on the imposition on, I think they didn't keep the dustbin outside their one of the showrooms. I think what purposes these will serve? There has to be some linkage with the materiality. Ultimately, stakeholder doesn't want to be knowing each and everything in and out of what a company is doing. They also want to be feeded with what actually makes sense, how it impacts the organization, how it impacts them. While it may to some extent give an indication as to the culture or behavior of a corporate, because if a corporate keeps on receiving continuous multiple number of fines and penalties, then it also highlights that there is some kind of gaps in the internal management in order to follow processes which are triggering such non-compliances. But at the end, we also need to see what is material. I think earlier, because it was in para B, regulatory actions, there was still much room to determine the materiality and take a call. But by being shifting it to para A, it's becoming very difficult for companies to actually set the process, even because, as I mentioned, I have operations in, for example, Vienna. In some corner of Vienna, there is a factory. Their regulator imposes a fine there. The time it will come back to me, all things I need to evaluate in terms of what needs to be done, how impactful is that.
Okay.
So a lot of things are there which needs to be looked into.
Okay. Mohini, there is one issue that how are the debt listed entity which have
Sir, I
listed?
think ये तो discuss कर लिया ये वाला, वो तो कि market cap है ना, तो it will be only for equity.
No, I'm coming out differently.
अच्छा.
Now he is, suppose today is clear that debt listed company is not coming into this category. Okay. But interestingly, this question is posing some new things. Suppose they make it a point that debt listed company is also included, and they are coming out with multiple ISIN number. So it means that they will put restriction on all ISIN number.
Yes, because debt is listed. So different series have will be given the different ISIN. So if DP PAN number will be freezed, so at a particular ISIN, that means all ISIN of that particular company get freezed in that case.
Okay. Okay. So Ankit, that was a point that suppose SEBI is saying, no, this they are doing, and then what will happen? So I think it is not a big issue when you are putting giving an instruction to the DP, the depository. You can give that this is the all ISIN number should be, you have to just,
Should be freezed. Huh?
I think you need to checkbox all the ISNs in your system and then
Correct.
upload the details.
Ankit, this BRSR concept, will you think that this will bring new changes? And sometime I'm feeling that you are in corporate world and this ESG and BRSR is something which is different. So what will be the future?
I think the very future, as I mentioned, I think for ESG as a service and as a subject, I think it's next decade. I think we all be talking about ESG only. And I think personally also as an individual, we should also start taking things seriously, considering the kind of floods that we are seeing in the country over the years and the impact that climate change is bringing. Both in terms of business, how we operate as an individual, how we operate as a society. I think this is now becoming an imperative topic for everyone. And since businesses are the biggest contributors towards, I think, ensuring that they do things sustainably, bring least of the damage to environment. I think it will always be up to them to begin with to see how they will be playing their role in ensuring that all of us or all of our future generations will have a safe future to come. So considering it, BRSR, I think it's time that we should actually change BRSR name to ESG report.
Yeah,
Some other report. I think BRSR per se is very confusing itself. Then it's BRSR, then now BRSR core, then there was also ESG. So globally, when you see all these GIR standards and other standards, they only, I think, talk about the ESG reports and other things. So I think SEBI going down the line, I think also need to change the BRSR as an ESG report. So it has a common nomenclature, can be read across commonly throughout the globe. And I think we as a professional, we should take this as one of the very big opportunity to work in this area, to understand how these things work, most importantly environment, industry processes, even on the social element, like we do a lot of labor law diligence, labor law advisory. So to understand how these compliances needs to be undertaken, how you can give better working conditions, well-being of the employees, all these things you now need to understand.
I was coming on the same point, that first governance has come, then GRC has come, then BRSR has come, and then ESG. So the point which I was asking you, you have given answer in advance, that why the confusion and what is the difference between this ESG and BRSR?
I don't think it's the nomenclature. I think objective is the same. Both intends to outline the initiatives of a company on the subject matter relating to ESG, and BRSR is nothing but an ESG report with just a different title, because the content that you outline in the BRSR report is all the factors, the principles are related to ESG. And I think it is why it is being said as business responsibility. I think it is arising of the fact that the 9 principles that are enumerated therein are arising out of the policy that the government has approved, which are, I think, corporate business responsibility related guidelines. I think from there the name itself is being derived. But I think going forward, SEBI will definitely bring in a common nomenclature, because these days also, sir, companies are also, multinational corporations or even in companies in India who have global operations are preparing both. They're also preparing BSG and then the BRSR, and they're also preparing specific ESG reports like on GRI or other specific set of standards, which can easily be understood by their global stakeholders.
Okay. Mohini, there is a question for you.
Yes, sir.
The insider trading law is always coming out. Previously, it was a very small law. Now you talk about the insider trading law. Itself is a big point, and we have organized various programs on insider trading. We organize on contra trade. We organize for DPG, the issues connected to DPG, trading window closer. So if you see the insider trading, and then multiple subsections are creating, and in all sections, you have seen we received 50, 60, 70 questions and confusion in the. What is your opinion on this? That insider trading law, what changes SEBI should do? Because now they are also doing some more changes which will bring. So in your opinion, the insider trading law is matured, clear, or so many things has to do because you are interacting with corporate world. So what is our view?
With respect to the insider trading, so it's not at a maturity level right now in India. Gradually the changes are coming, and whatever the difficulties the corporates are facing, the SEBI accordingly considering those changes, that's a good point, and then they are coming out with those changes, and more clarifications in this insider trading law is coming from the SEBI side itself. So if we talk about that, because in the insider trading, many of the things are there which in India we have started and it's not in other jurisdictions. Like if we talk about the structured digital database, so it's in India only we have this provision, but outside India, there is no other jurisdiction which is following these structured digital database. There are many other things also wherein we have taken the first step. Once these kinds of things have been implemented, and if we see that since 2018, December 2018, the major changes have come. And also there are few changes in the insider trading law has came, which made it practically the companies has to do a few things. Like the data compilation at the company, and SEBI has started because this slowly they are evolving, because if we talk about earlier in the insider trading cases, generally the SEBI faces challenge that to create a link that how the person has got that insider information. So for gathering those information to ease out that process, and also so that the persons who are guilty of insider trading will come the cases can be settled at fast. So they have started from the company itself that they will start gathering the information from their designated person. So slowly and gradually we are evolving in this insider trading. But yes, insider trading per se, it's not a very small law. It requires the designated person as well, because it's the individual who has to comply with. So they have to first learn, and they have to think it like what the code of conduct is. And in its organization behavior, they have to adopt that thing.
Okay. Any other thing which you think that is there is a need of changes required in insider trading law?
The per se, we think that because generally the people who are at the top level management, KMPs like CFO, CEOs, MD, we talk about, they are generally be in continuous possession of the UPSI. So for them to get the pre-clearance, if they want to trade in their securities, it will be very difficult, even if for any genuine reason they want to, because they can't give a declaration and they can't say that I am not in possession. Many a time in many of the cases are there. So I think one of the provision in this insider trading is that they can go for the trading plan, that they can in advance of 6 months for a 12 months period, they can say that what the trading I can do during a next 12 months period. So, but per se, it's very difficult for any person to think it of that what he can do in the next 12 months. So I think, and that is also compulsory for the person to undertake that trade.
So only I think this is one very big demand from the corporate world.
Corporate, yes.
That this trading plan issue should be settled down, and I hope SEBI is working out. Let's see. We will
wait
for them. We will discuss this issue, and I think on 18th we are organizing one program on trading plan and trading window closer. So that time we will discuss this issue in detail. And we hope that something will bring, SEBI may bring out. So we will discuss this issue, and whatever points the corporate worlds are facing, we will definitely tell. Okay. So now I think this month the amendments were very limited, and we have tried. Anybody has any questions, please write to here. We can discuss this issue. Otherwise, this is this month, I think, less. Nikita, you have any new point which you want to tell, which has come?
No, I think I've
Any other point, Ankit? You want to cover anything relating to company law? Government should do it.
I think so. I think
Portal
if V3 can start working fine, that would be great.
Okay. And the B3 database, they are coming out. Is there any change in this?
I am not aware, sir. I am not aware.
Okay. Okay. So friends, I think we have to close it here because Madan sir and Amit is stuck in one court matter. So thank you, Amit, Ankit, thank you, Mohini, thank you, Nikita, for giving the detailed one, whatever changes has taken place. Friends, as you are aware that this is one program which we are just doing for the benefit of our friends, that whatever you have missed out, so you can cover up here. So I request all of you, please pass on this message to all, because as compared to the topic, specific topic wise, I'm seeing less participation here. Okay, so if you can communicate to other people that how useful this program or this particular first webinar, so you can get all updation. It will be useful for all. So this journey which we are doing will continue, and on 11th August, our next webinar, we are doing on very interesting topic, that is digital lending and first loan default guarantee, that is FLDG, which RBI has come out new guidelines. As you are aware, Paytm, Payphone, various digital platform providing lending, and in this various issues are there. So you should know your right, the company should know what are the issues and the legal aspects that we will discuss on 11th August, digital lending and first loan default guarantee, FLDGC, on this. And then on next Friday, that is 18th August, we are doing program jointly with BSC and NSC and the depository relating to trading plan and trading window closure, which is a very, very important issue. So thank you very much all. Thank you for participating, and thanks for whatever you suggest improvement in this particular type of program. Please write to us. If you want any specific topic, any specific person, we can call them. So be interactive, write to us. It will be helpful to us to modify things. And if you want some suggestion to improve our webinars, please write to us. Our journey is not what you say, it's not a short-term plan, it's a long-term continuous plan. We will continue this holding this type of webinar. So thank you very much. Thank you, friends.
Thank you, sir.